Good afternoon, everyone. Thank you for joining us for our webinar today. My colleague, Josh Stevens, and I will be talking about developments and trends in TCPA class action litigation. And there's a lot of topics that are up in the air in and around that subject right now. So we're very happy to have you join us today. Just a couple of housekeeping matters before we start. Because the broadcast today is only for 30 minutes, we will have the opportunity to accept some questions in the chat box, but given the time limitations, we might not be able to answer those questions during the presentation, but we'll be happy to follow up with anyone who submits questions after the broadcast so that we can address those for you. In addition, at the time of registration, we did receive several questions, and we have taken those and incorporated answers to those questions into our presentation today. So we'll be addressing the questions that everyone submitted at the time they registered. And then lastly, this webinar is being recorded. It will be available to anyone within 24 hours after now to obtain on our website, so that you may re-listen to this if you would like, or that you may feel free to share it. And so with that, I will briefly introduce myself and then pass it over to Josh to introduce himself. My name is Lisa Messner. I'm a partner with the law firm of McMurray & Schuster, and I'm also our law firm's litigation director. My practice focuses largely on class action defense and complicated business disputes. And obviously, a lot of our class action work is focused into the TCPA area. So happy to have an opportunity to speak to everybody about some of the developments in that space today. And with that, Josh, would you like to introduce yourself?
Sure. Thank you, Lisa. As Lisa said, my name is Josh Stevens. I'm a senior attorney here at McMurray & Schuster. Unlike Lisa, I try to typically stay as far away from litigation as possible over in our compliance department. So my job is to help our clients develop those policies and procedures and those practices that help hopefully prevent them from getting into litigation, or at least giving them strong defendable positions once they do. My practice covers TCPA, telemarketing generally, as well as the areas of privacy and data security, which are ever growing.
All right, very good. And with Josh and I being lawyers, we would be remiss if we didn't offer this disclaimer to indicate that the materials provided in this presentation are for informational purposes and do not constitute legal advice. The transmission of this information is not intended to create or constitute an attorney-client relationship. Every situation is different, so if circumstances are presented that are individualized to your circumstances or your business, you should seek the advice of an attorney specifically as related to those facts. And so now that we have that part out of the way, I am going to hand it back, I'm going to provide a brief overview, and then I'm going to hand it to Josh to start talking about the Facebook case, which I know a lot of people have questions about. And so today the topics we're going to cover are the Facebook case, which is before the Supreme Court right now, and specifically what is going to be the definition of an ATDS moving forward. We're going to talk about the Rogers versus Postmates case, which is a recent ruling that discusses some interesting angles regarding TCPA vicarious liability. We're going to talk about the Johnson case, in which the court declined to award an incentive to a class representative. That's an additional payment. And we're going to talk about what implications that provides. We're going to talk about the Salcedo and its progeny and what can constitute harm under the TCPA. And then we're going to wrap up with a couple of developments in the TCPA space regarding personal jurisdiction and whether or not the TCPA might have been unconstitutional for a period of time. And so with that overview, I will then hand it over to Josh, and he is going to talk a little bit about the Facebook case, which Josh has some very unique insight into.
Yeah, thank you, Lisa. And I imagine for those of you attending today's broadcast, the Facebook case is probably at top of mind because it really gets to the core of the TCPA and particularly the litigation around the TCPA, and that's the ATDS definition. So just to remind everyone, refresh everyone's memory, there is currently a circuit split in the way that an ATDS is defined. On one hand, you have this expansive interpretation that came out of the Marks decision in the Ninth Circuit and then was also adopted in the Sixth Circuit and the Second Circuit that essentially kind of rewrites the ATDS definition to mean equipment which has the capacity to store numbers to be called or to produce numbers using a random or sequential number generator and then dial such numbers. So remember there's that clause in the ATDS definition about using a random or sequential number generator. And really what these cases are arguing about is, does that clause modify the word store, the word produce, or both? And in the expansive interpretation from the Marks court, they said that only modifies the word produce. So a system that stores numbers to be called and then dials them like a predictive dialer could be an ATDS. On the other side of this split, we have the narrow interpretation, which comes out of the Seventh Circuit, the 11th, and then arguably kind of through the third. Not the case in the Third Circuit wasn't exactly on point, but pretty close. Most people see it as validating this position. And that interpretation, right, is that the equipment has to have the capacity to use either a random or sequential number generator to either produce or store numbers, which are then dialed, right? So that random or sequential number generator component applies to both words, produce or store. Under this definition, again, something like a predictive dialer that's just storing numbers from a list, it's not using a random or sequential number generator, would not be an ATDS. And so we have this circuit split, right? And this, I mean, really, it gets to the heart of the ATDS definition and to TCPA litigation. So because this is such a critical case, our firm acts as general counsel for the Professional Association for Customer Engagement, PACE. We worked with Noble Systems Corporation to file an amicus brief in the Facebook case, and I encourage you all to go check it out. It certainly consumed a large portion of my life for a while, so the more readers, the better. And so what this brief tries to point out to the court is that when looking at this definition, how Congress intended it to work, one needs to look at the technological context of the time. And both the 11th Circuit and the 7th Circuit did that in their interpretations, and that's how they came to the narrow interpretation. And that's essentially the position that Facebook is taking in their petition, right? And in their merits briefing is, look at the technology of the time. So not only does this reading make sense from a grammatical perspective, but also from a technological perspective. Because at the time the TCPA was passed, there were systems that used a random or sequential number generator to produce numbers for immediate dialing or to produce and then store numbers for later dialing. Both of those existed. So our argument is it's not surplusage for that clause to modify both words, store and produce. Obviously, Dogood feels otherwise. And in fact, they just filed their brief, I believe it was last week, and the PACE comments, or the PACE amicus brief was the only amicus brief that they spent any considerable amount of time trying to argue with. They spent almost a half a page of they put a footnote that was almost a half page long trying to argue with PACE's position. And so I think that just was kind of intriguing from having worked on it to see that clearly they must have felt like this brief was a bit of a threat or else they wouldn't have tried to argue with it. The government also supports the narrow interpretation. In their brief, essentially what they focused on, though, was just grammatical construction, that when you look at the rules of grammar and you apply it to the way that this was written, this is the way it should be interpreted. Duguid has challenged that in their brief, and in fact, they've included sentence diagrams from like elementary school, trying to piece out the different interpretations. So it's going to be really interesting to see what happens. The oral arguments are coming up, I believe it's on December 8th. It's likely we'd get a decision, hopefully sometime early spring, maybe that February, March timeframe. And whichever way it goes, we will at least finally have a concrete definition, a concrete interpretation. Obviously, I think most people want it to go for the narrow side, and we think there are a lot of good arguments there. And with Amy Coney Barrett potentially being on the court and potentially hearing the case, she was on the panel from the Seventh Circuit that ruled in favor of the narrow interpretation, so she probably would support that. And one of the questions that we got before today's presentation was, has there been progress, truly defining a robocall? And I think this is the core thing. When we're looking at, calls that are made using an ATDS, this case is going to be the blockbuster on that. So we'll see what happens. Stay tuned. Obviously, watch our blogs. As soon as something comes out, we'll know it. And Lisa, let's talk about your blockbuster case here with Postmates.
Yeah, thanks, Josh. And so in all transparency, this case was a case that was handled by our firm. Me and my colleague Chris Wagger were lead counsel on this case. It was a case that was brought, interestingly enough, by way of background, in the Southern District of Florida originally. And later on in the presentation, I'm going to talk about some 11th Circuit precedent regarding injury in fact that caused that case, this Richard Rogers case, to be dismissed and refiled the next day in the Northern District of California, where there's different controlling precedent in the Ninth Circuit as to what constitutes injury in fact. And so when the case was brought in the Northern District of California, we challenged it on 3 different occasions at the pleadings phase, which is at the time that the complaint was filed, indicating that there was not sufficient facts pled to show a theory of vicarious liability, because in this case in particular, Postmates did not send the text message at issue. It was a recruitment text that was the subject matter of the litigation, and the text was not sent directly by Postmates. It was sent by a vendor. And that means that under the TCPA, the only way Postmates could be liable is through a finding of vicarious liability. And the complaint had facts containing things like Postmates had retained some unknown third-party vendor, and that person or entity sent the text, but it was very vague on any facts that would be required to show vicarious liability. And so the court agreed with our briefing in which we said that any kind of complaint that seeks to hold someone vicariously liable under the TCPA would require facts to support one of the theories of vicarious liability, and those would be actual authority, apparent authority, or ratification. The complaint was amended 3 times, and those facts were never included specifically within the complaint. And so the district court dismissed the complaint after the after the Third Amendment with prejudice. And so this was it was obviously a huge victory, because the dismissal with prejudice is adjudication on the merits, and the case cannot be brought again. The case is currently pending appeal to the Ninth Circuit, and obviously I'm not at liberty to comment about that too much because it's still active litigation. However, briefing in the case is to start in November. And so I suspect we will have a ruling on that also probably in within the next 6 months. So it'll be interesting to see. I think it changes the landscape of the types of cases and the types of facts needed to try to hold someone vicariously liable under the TCPA, and it really presents some interesting wiggle room from a defense standpoint. And so with that, that's I guess about what I have to say on the Postmates case. We're obviously very proud of our result there. But Josh, I'll pass it on to you to talk about incentive payments.
Yeah, and it's interesting with the class action cases, right? How do we get plaintiffs to participate in those cases? Well, we give them we give them awards, we give them incentive payments, and so we have this decision of the 11th Circuit from last month that says, you know what, actually, you can't do that. Incentive payments to class plaintiffs are not permissible, and the court rooted this in some Supreme Court cases from 1882 and 1885, the Greenough and Pettis cases. And what those cases held was that you can recover attorney's fees and direct litigation expenses, but a plaintiff in a class action cannot get a payment for personal services or personal expenses. And what the court here in the 11th Circuit said is an incentive payment to a plaintiff is really compensation for the personal services of that plaintiff in attending depositions and taking part in the case, and that is really not permissible under these decisions. And one thing that was kind of interesting here is that the plaintiff, of course, says, well, these are routine. Incentive payments are always given to the lead plaintiff. And the court said, I'm just going to read this because I thought this was just so kind of perfect. Court says, but so far as we can tell, that state of affairs is a product of inertia and inattention, not adherence to law. The uncomfortable fact is that the judiciary has created these awards out of whole cloth, and few courts have paused to consider the legal authority for incentive awards. And so, at least in the 11th Circuit, based on this decision, and I haven't seen yet whether they're trying to appeal this further, it might be significantly harder to get a class, a lead plaintiff to head out in front of a class, given that they can't get an incentive payment. So just something interesting to raise there that plaintiffs' attorneys might find frustrating moving forward.
And Josh, I would just quickly add to that point that typically under the TCPA, the remuneration that the plaintiff would be entitled to see would be the statutory damages, the $500 to $1,500 per call, per text, per violation, whatever it were. And in the absence of the incentive award, the extra amount of work and burden on the plaintiff, it seems to me like that will present a very large hurdle in finding class representatives going forward. So I think just wanted to comment that I think that is a very interesting case.
Yeah, absolutely.
All right.
So tell us about Salcido.
Yeah, so we have a kind of a pair of cases here. And so by way of background, Salcido versus Hanna is an 11th Circuit decision in which the court held that the receipt of one unsolicited text message fails to show an injury in fact requirement sufficient to establish Article 3 standing. So what that means is, if you break it down, that the court is saying to get into federal court, you still have to meet an injury in fact requirement that's set forth in Article 3 of the United States Constitution. Otherwise, there is not a justiciable claim that the court can take jurisdiction over to hear. And in analogizing the text message, the court made reference to the level of annoyance that receipt of one text message is equivalent to the nuisance of a flyer blowing in one's face in the wind while they're walking down the street. And it's very funny that they make that analogy because they go on to explain why it's analogous to that, and it's not actually a concrete harm because there's not a dispossession of the use of the phone to receive a text, and they kind of go into an analysis of modern telephone equipment, to receive a text. It doesn't prohibit you from the use of your phone. It's not likely to excessively drain your battery, that most people have data plans that do not cause additional charge by the receipt of one text, and they went into the full analysis. And so based on the reasoning of the Salcido case, we now have another case that is currently pending before the 11th Circuit, the Eldridge versus Pet Supermarket case. And in that case, a district court in the Southern District of Florida kind of took the reasoning of the Salcido opinion and went a little bit further and held that the receipt of 5 unsolicited text messages is insufficient to show an injury in fact that is required for that federal court standing. And so that case is on appeal currently. It's not been decided yet. It's going to be very interesting to see if the 11th Circuit expands out numerically the number or volume of calls, texts that are required. And interestingly, I would just go back to Salcido. The court specifically carved out that it was not opining on other types of TCPA violations, such as pre-recorded calls or live calls that violate the do not call list. It specifically did not opine on that. But we've seen some interesting arguments developing that are relying on the Salcido rationale to set forth even things like the delivery of a pre-recorded voice message that was never answered might be insufficient to confer Article 3 standing. And so there's been some interesting arguments out there raised, and so there's a little uncertainty in and around how it's going to come down. I find it extremely interesting to watch these kinds of trends. But as a practical matter, we have to question, is this holding really helpful as a defense for somebody who has been accused in a class action of a systemic, TCPA violation? And so one consideration that we kind of talk with our clients about is there's certainly ability to challenge in the 11th Circuit that the receipt of one unsolicited text message is not injury in fact for purposes of federal court jurisdiction. That does not preclude the plaintiff from filing necessarily in state court in the forum state. So there could be a basis for that to occur. And if that occurs, it raises jurisdictional issues, which is kind of our next topic to discuss. But always in considering your strategies and your defenses, you want to be fulsome in your thinking, because in this particular instance, although it is a way to get a matter out of federal court, it is not necessarily a complete defense to this type of violation.
Yeah, and Lisa, my general thought on this, just to jump in here for a second, is, you always plan for the worst, hope for the best, right? And so we don't know whether this is going to get expanded beyond the 11th Circuit, right? You raised these jurisdictional issues where, and maybe a consumer could bring a claim in state court. So I don't think that this negates or should put anyone on any sort of false belief that they don't need to have compliance in place if all they are going to do is send one text message. You still need those compliance programs, right? You still need to build that out because there's just too much uncertainty here. So you want to protect yourself. This could be potentially a defense you could raise if something were to happen. But if you put the compliance measures in place so this doesn't happen, that's even better.
And I agree, Josh. I would just add that, obviously the things we're talking about today are interesting trends in case law, but none of them are foolproof. And so Josh and I may say sometimes semi in jest, although it is completely true, that if you do not see Josh for your compliance measures, it is likely you will see me. And you would be much better served as a best business practice to make sure that you have fulsome compliance measures in place so that we're not even having to discuss what may or may happen in a certain jurisdiction or different defenses. So I agree with that wholeheartedly, Josh.
Yeah. So we've got 5 minutes left. Lisa, tell us about the personal jurisdiction, and then I'll wrap us up with some TCPA constitutionality.
Yeah, I want to make sure we leave time for that because it's a really interesting opinion. So I'll be brief on the jurisdictional issues. As I alluded to when we were discussing the impact of Salcido and possibly having to get a case moved over to state court, there's one additional little layer that's developing. Now, the district courts are currently split, and we don't have clear direction from the circuit courts on what's going to happen. But the United States Supreme Court issued a ruling in the Bristol-Myers case that does have an impact on nationwide class actions. And there's a division, as I said, some courts are holding that personal jurisdiction can be lacking over a non-resident defendant. So this might be a defendant, for instance, that's incorporated in Delaware and does business in Florida, but is sued then in California. So they're not a resident of California for purposes of jurisdiction. There might be a challenge to say that defendant, that there could not be a nationwide class action certified in that state over that defendant. That it could only be a class action for members of the forum state. So it's a potential defense that might allow a class size to be cut down. But again, going back to the reminder that the compliance measures are key to avoid these issues even coming up, this isn't a complete defense, because what could happen to counter that is that the plaintiff could dismiss the case without prejudice and then just refile in the state where the defendant is located. And so it's not a foolproof defense, but it's developing interesting area of law that we wanted to briefly raise with you. And now I'm going to hand it over to Josh to talk about the more interesting developments that are coming in and around whether the TCPA may have been unconstitutional for a period of time.
Yeah. So as many of you may recall, back in July, the Supreme Court issued an opinion in Barr versus American Association of Political Consultants related to whether the government debt collection exemption rendered the TCPA unconstitutional. Remember, in 2015, there was this exemption put into the TCPA for calls made to collect government-backed debt. So the Supreme Court in that decision said, yep, that was unconstitutional, but they did not go as far as I think consumer groups, or not consumer groups, some callers groups wanted, which was to say that the whole TCPA was unconstitutional. They said, no, we sever that exemption and the TCPA is fine. Well, last month we got this case from the Eastern District of Louisiana, Creasy v. Charter Communications. And in this case, there was a series of calls, series of communications to the plaintiff. There were 31 of them. And what Charter challenge was in their motion to dismiss was, well, the TCPA was unconstitutional, right? The court said this. So what the Eastern District of Louisiana held was that, in fact, during the period that the government debt collection exemption was in place, so from that was around mid-2015 up to July 6th of 2020, the TCPA was in fact unconstitutional. And any calls or texts that were made during that period that would otherwise violate the TCPA are not actionable. It's as if the TCPA didn't exist. So they granted the motion to dismiss for 30 of the 31 calls. There was one call that was after the July 6th date. And so the case is continuing with regard to that one call. And so if you're finding yourself in a defense position, this could be an argument to raise to mitigate the number of violations if some of those violations were predating July 6th. If those violations are after July 6th, then obviously I think, this isn't going to work. But it's a real interesting argument. We'll see if it holds on appeal, assuming that they don't settle. But Yeah, I think this could be an interesting angle. And what I also find interesting is a lot of this jurisprudence is coming out of the 11th Circuit. It's like the 11th Circuit courts have sort of woken up to some of the what in my opinion is some of the egregiousness related to the TCPA. And so they're trying to put some parameters around these cases. And with that, we did have two other questions real quick in the last 60 seconds that we received beforehand. The first is, how will the FCC's reassigned number database affect the nature of TCPA litigation? Well, the reassigned number database is going to provide a certain safe harbor for calls made to reassign numbers if the person scrubbed against the database, if the caller scrubbed against the database, and for whatever reason, the database returned the incorrect result or something happened that just caused a mismatch. The issue here is twofold. One, it might all be moot effectively when Facebook comes out. We'll just have to wait and see. But secondly, and more importantly, the reassigned number database is still a long way from being put in place. The telecommunications carriers are just going to start reporting, some of them in January, some of them coming up in July. To my understanding, when I checked this morning, the administrator of the database still hasn't been selected, so there's still a lot to get put in place there. And then the other question was any additional insights into increased D&C violations in litigation. Lisa, if you have any thoughts on that one.
Yeah, in terms of any kind of spike for D&C violations being asserted, I would say that I'm not seeing an increase in those types of claims. My general experience is if those claims exist, they're oftentimes asserted. I will say that oftentimes they end up getting dismissed because if you don't have the two calls within the 12-month period, it's not going to trigger. But I'm not noticing any kind of increase in those cases. It will be interesting when Facebook comes down, if it's more restrictive in definition, if we do see that going forward, but I'm not seeing it right now.
So thank you, Lisa, and thank you everyone for attending today. As Lisa mentioned, the recording will be available within about 24 hours on our website, and you may also receive a follow-up email here at the end of the presentation giving you additional information about that. If you submitted questions during the course of the presentation, we will follow up with you with responses to your question. And with that, I will wish you a great rest of your day.
Thank you.